2018-425, State of Arkansas versus Charles Gillingham. The affidavit reflects employment by Mr. Gillingham, but doesn't reflect any income. So,
I just got
based on what's contained in the affidavit, the court will make the appointment of the public defender's office to represent him.
Your Honor, although we are just being appointed, I would like to say before we do his plea that Mr. Gillingham and I visited about this possible plea yesterday afternoon at the jail. So I am familiar with this case, and he is familiar with what the plea is, much more so than just seeing his plea for the first time this morning.
The court is making the appointment, and will note on the record that there's been previous communication with Mr. Gillingham at the jail leading up to the proposed plea.
Thank you, Your Honor.
Mr. Gillingham, you appear at this time for arraignment on the charges, and it's my understanding from reviewing the plea documents that have been submitted to the court that at this time you're prepared not to change your plea but to enter a plea of guilty based on an agreement that's been worked out for you by your attorney, Mr. Cooper.
Yes.
And have you had a chance to thoroughly discuss the terms of the agreement and the punishment you're to receive with Mr. Cooper?
Yes, I have.
So do you feel you thoroughly understand what the agreement is?
Yes.
And you are prepared to enter a plea on it?
Yes, sir.
One of the issues that's raised is because you haven't, you were only charged last week, and this all relates to, I guess it was 2 weeks ago, but I mean, you were charged very recently, and you've had limited contact with the public defender who's representing you here today, but you have had a sufficient contact for you to feel comfortable that he's done you a good job?
Yes, I have.
Are you willing to accept the fact that I'm sure you're familiar with the idea that if he had more time, there's a lot of things he could look into in your case to investigate the case. He could also kind of figure out defense strategies that might be applied, review motions to suppress evidence that might be filed. All of those kind of things could be done. Do you understand that?
Yes, I do.
And understanding that he could do that with more time, are you satisfied with this agreement enough to waive any extra time and go forward with the plea today?
Yes, yes, I am.
Okay. All right. Based on those statements, then we'll proceed. On the charges against you in this case, which is possession of controlled substance, methamphetamine, a Class D felony. How do you now plead?
Guilty.
You're in this plea pursuant to the agreement that's been worked out. That agreement is contained in this written plea statement that I'm holding up. Have you reviewed this plea statement and initialed and signed it?
Yes.
In going over this plea statement, do you feel you understand what's set out in the plea statement?
Yes, I do.
You then understand the nature of the charges against you and the full range of penalties that you're facing?
Yes, I do.
You understand the rights that you give up or surrender by pleading guilty?
Yes.
The most important right you give up by pleading guilty is your right to a jury trial. That jury trial hasn't even been set in this case yet, but you would have a constitutional right to a jury trial, and by pleading guilty you give up that right. With that right to a jury trial, you're also giving up the right to have an attorney represent you, assist you in preparing and presenting your case, and going through the whole process with you. You're giving up the right to confront witnesses that would appear testify against you at trial. And finally, you're giving up the right to appeal. All of those are rights you give up by pleading guilty. Do you understand that?
Yes, I do.
And understanding what rights you're giving up by pleading guilty, are you still willing to plead guilty?
Yes.
Are you pleading guilty here today freely and voluntarily?
Yes, I'm pleading guilty.
Has anybody in any form or fashion forced you into this plea?
No.
I know this gets tedious, it does to me too. All right. And in pleading guilty, are you admitting to your participation in the criminal activity?
Yes.
Are you admitting that on or about September 12th of 2018, here in Mountain Home, Arkansas, you had in your possession a quantity of methamphetamine?
Yes.
Based on those statements, the court's going to find the basis to accept the defendant's plea of guilty, finding he has freely and voluntarily entered his plea of guilty, done so after consulting an attorney, and he has admitted his actions that constitute the crime. On that basis, the court at this time formally finds the defendant guilty of possession of controlled substance, methamphetamine, a Class D felony, and sentences him in accordance with the agreement that's been presented to the court, sentencing him to 3 years of supervised probation, subject to the standard terms and conditions of probation of this court. Court costs are imposed in the amount of $200, a fine of $2,000, the statutory DNA fine of $250, booking administration fee of $20, $200 in public defender's fees, and a drug court assessment is made in the amount of $125. All of those amounts will be due and payable as a term and condition of his probation. Payments are to begin within 30 days of this date and be made each month within those 30 days, and then each month thereafter until the full amount is paid. The amount of payments will be at least $100 per month and continue at or above that level until all amounts are paid. That'll be the order of the court. Placing the defendant on probation, the court has reviewed and is signing at this time the written terms and conditions of probation of this court. Those written terms and conditions of probation, once I've signed them, are in order that you're required to comply with these written terms and conditions of probation. I note that you signed the acknowledgement indicating that you have read, understand, and will comply with the terms and conditions of probation. On that basis, I'm going to direct at this time that you meet with the probation officer and get set up on probation. You may be excused at this time. (2018-418) State of Arkansas versus Mark Zran. Court is making the appointment of the Public Defender's Office in case 2018-418 and also signing an appointment in 2018-67. I guess that's another case already on the docket, is that correct?
That is a probation violation, I believe, Your Honor.
Yeah, but I guess that's on Judge Putman's docket.
Your Honor, when I visited with him at jail yesterday, it was the first that I was aware that he had the probation violation, and now I understand that it's a revocation hold from talking to Mr. Etheridge.
I see. Okay. All right, Mr. Zan, we're setting your case, that is 2018-418, this need on the charges against you in this case of possession of drug paraphernalia, Class D felony, theft by receiving, Class A misdemeanor, endangering welfare of a minor in the second degree, a Class A misdemeanor. On those charges, how do you now plead?
Your Honor, he enters a plea of not guilty.
Plea of not guilty is entered on Mr. Zan's part. I'm setting this matter by scheduling order. November 29th will be the next court appearance date. March 7th will be set of 2019 will be set as a pretrial date. May 16th is a plea deadline date, and the trial will be set during the week of May 20th, 2019. Those will be the dates set for him.
Your Honor?
The probation violation, I'm going to, do I need to arraign him on that? Let me look it up.
Your Honor, hadn't been served on him yet, so.
Okay. I guess we really can't. I was gonna set him down in front of Judge Putman at the next, Judge Putman's next date. which will be October 4th.
Your Honor, is it possible if I can get a lift on my bond?
What do you think a lift on your bond is? Are you wanting your bond reduced or one set on it?
Your Honor, I think after visiting with him, I don't mean to just completely interrupt for him, but I think what he's asking the court is to lift the hold on the probation. Because he made me aware of the probation hold, as I just told the court yesterday. I don't know what the position of the state is. As I understand it, his current bond on his new charge is $2,500.
Right. That's what I looked
And he
at.
can make that bond, but he can't make it as long as there's a hold on him. I think that's what he's asking of the court.
No, I'm not gonna remove that at this time. That matter needs to go, in front of Judge Putman, who's gonna be handling your revocation. So the answer is no, I'm not going to lift your, probation hold. All right, you may be excused. Court is calling 2017-388, State of Arkansas versus Joshua Hannaford. Apparently, the defendant was arraigned on charges originally back in October of 2017. The next entry we have is his non-appearance. And it reads, the defendant is incarcerated in the Hale County Detention Facility. That's the way the docket entry reads. And he was ordered to appear in February of 2018. On February 8, 2018, he failed to appear and an alias warrant was issued.
Before the first missed appearance, Your Honor, I was already incarcerated. I've been incarcerated since before that court date.
What do you mean?
I just got
Where were you incarcerated?
Missouri.
So you've been incarcerated in Missouri?
Yes, and I just got released.
Your state had to go get Mr. Hanford.
Yeah,
Okay.
and I've still been incarcerated since before the first missed court appearance. I was on bond at the time. I was hoping to ask to get my bond reinstated and come back with an attorney.
Well, have you made any arrangements to secure an attorney?
Your Honor, he's represented by our office, so
Is he?
we just have not had contact with him because I think he's correct in what he's saying. He has been incarcerated in Missouri.
All right. Well, we need to get him on a scheduling order. This is on the charges of possession of a controlled substance. Do we know whether the crime lab has been set off on this case? Do we have crime lab results back?
No, sir, we
Not
have not
yet,
put them
Your
back.
That's sort of disappointing to me.
Sort of common, you know, Your Honor.
I know, but we're a year out on this one.
We'll check in just a moment, Your Honor.
Okay. In any case, the charges are possession of controlled substance, methamphetamine, Class D felony, possession of drug paraphernalia, Class D felony, and furnishing prohibited articles, a Class C felony. There was a plea of not guilty entered in front of Judge Putman on October 5th of 2017, and that's apparently the one and only time he was actually in court, as far as I can tell, before he was taken off to Missouri. All right, this case is assigned to this court's docket, so the court is setting it down. Court's going to set this matter on a trial schedule that will read as follows. That he's set for trial during the week of March 25th of 2019. you'll have a plea deadline date of March 21st of 2019, a pretrial deadline or pretrial hearing set for February 21st of 2019, and he's to reappear on November 29th in front of this court for check on the status of the case. So those are the dates that will be set on Mr. Hannaford's scheduling order. Now, Mr. Hannaford, you were requesting about bond. Where is it you're going to be living at this point?
My home is in Gainesville, Missouri. I'll make it for court, Your Honor. I have no intention on job. The only reason I missed court ever to begin with was due to my incarceration.
Well, that doesn't relieve me from some concern because, you know, this case has been on hold for over a year, and it's directly related to the fact that you were in Missouri. Now, I understand you were incarcerated in Missouri, but I don't have any evidence to show that you're going to show up here in Arkansas at that November 29th hearing.
Well, I can
Court's
assure you
gonna
I
set-
absolutely
court's
will.
gonna set- I don't know what I'll have to go back and look.
$7,500, Your Honor.
I'm gonna set the bond at $15,000 cash or surety. If the bondsman who was on the previous bond wants to stay on it to the effect of $7,500, then that's fine with the court. But the bond now is $15,000. That'll be.
So, You're doubling my bond, Your Honor.
Yes, sir, I
I ask
am.
him, please, I didn't miss court due to this. It was this violation. This is what violated my Missouri case. So I returned to Missouri and was taken into custody then because of this violation. I've been in custody since.
All right.
I just got released on Friday. I will be here, Your Honor. Please just.
Well, as I said before, my concern is you didn't show up, and it was directly related to the fact that you were in trouble up in Missouri.
I'm done
Albeit
with
These
Missouri now.
charges may have gotten you revoked, so that indicates to me you are on probation already, and you live out of state. It's my opinion you are not a good risk to reappear, and I'm setting it at $15,000. That's where the bond's set. You
Your
may
Honor.
be excused.
Your Honor, before Mr. Hannaford is excused, since he has been away, and just, as he said, he just recently got back in our jail over the weekend, I'll come down and visit with him and get a much better address, and then I'll give that to Mr. Etheridge, and possibly the court could revisit the bond after I speak with him.
I'll be glad to reconsider.
Okay, thank you,
If
Your
I'm
Honor.
furnished something that makes me feel secure that this defendant will appear. As I say, the case is already a year old,
I understand.
and we haven't made any progress on it. All right, you may be excused, sir.
Thank you, Your Honor.
(2018-427) State of Arkansas versus Robert Weibel.
Your Honor, Mr. Weibel has retained me privately in this matter.
Okay. This is for arraignment on charges of forgery, a Class B felony, theft of property, a separate Class B felony. On those charges, how does Mr. Weibel plead?
Pleads not guilty, Your Honor.
That plea is duly noted. The case is set according to this on the Division 3 docket of Judge Putman. I'll order him to reappear on October 4th to get on Judge Putman's scheduling order. Unless there's something else, you may be excused, sir.
There is not, Your Honor.
2018-431, State of Arkansas versus Jeffrey Grigg. Mr. Grigg, I've looked up your case. The charges against you are fleeing, a felony offense, Class D felony, possession of drug paraphernalia, a separate Class D felony, fleeing on foot, a third Class D felony, and driving left of center, as well as reckless driving and no liability insurance. All of those are charges against you. Have you made any arrangements to be represented by an attorney?
No, sir.
Is it all the court's going to explain to you is that you have the right to an attorney, and what that means is you go out and hire the attorney of your choice. If you do that, that's you entering into a private contract with an attorney. I will advise you that you have the right to an attorney even if you cannot afford to hire an attorney. And what that means is if you decide you cannot afford to hire an attorney, then you're entitled to court-appointed attorney. The way you secure a court-appointed attorney through the court is you make application to the public defender's office. Those applications are there at the jail. You need to fill it out, sign it, and turn it in, and that application will get to the public defender's office. They will then make sure a judge reviews it and makes the decision of whether to appoint a public defender. So that's the way you get an attorney. At this point, you don't have one, so the court is going to ask you to enter a plea of guilty or not guilty on the fleeing, on the Class D felony fleeing. Actually, there's one in a vehicle or conveyance and one on foot. Possession of drug paraphernalia, also a D felony. And then driving left of center, reckless driving, and no liability insurance. On those charges, how do you now plead?
Not guilty.
I'm noting your plea of not guilty on the record. Your case is assigned to the Division III docket of Judge Putman. I'm setting you down to reappear a week from today when Judge Putman's over here to get on his scheduling order. That will be the order of the court. Now,
Sir, is there any way I could get a bond reduction?
well, I haven't even established what your bond is.
It's $10,000. I gotta stay here for 60 days on child support anyways, but in case this goes on further and further, if I can just see if I can get a bond reduction.
Why don't you discuss that with Judge Putman next Thursday? He's the judge handling your case. If you're going to be there anyway, I don't see any reason why I should start making decisions to reduce your bond.
Yes, sir.
Given the nature of the charges, I'm not going to, which are with two sets of fleeing charges. Bond's all about cooperating and coming to court. It doesn't sound like you're much disposed to do that. So, court's not likely to reduce it anyway, but take it up with Judge Putman. All right?
All right.
You may be excused.